2025, and later this year on October 21st, 22nd, and 23rd. I am the hearing officer for today's appeal, filed with the Civil Service Commission on March 27th, 2025, and docketed as case number D1-25-085. The appellant in this matter is Michael D. Proctor, Proctor. At this time, I ask that co-counsel for Mr. Proctor please stay seated, introduce yourselves, and spell your names for the record.
Good morning, Madam Commissioner. Attorney Daniel Moynihan, Moynihan, on behalf of Michael Proctor.
Good morning, Attorney Mark Russell, RUSSVLL, on behalf of Michael Proctor.
And my name is Zachary Green, Associate for Attorney Moynihan, on behalf of Michael Proctor.
Thank you very much, Mr. Moynihan, Mr. Russell, and Mr. Green. The respondent in this matter is the Massachusetts Department of State Police. At this time, I ask that counsel for the department again please stay seated, introduce yourselves, and spell your name for the record.
Good morning, Commissioner McConney, Attorney Quinnan. My name is Stephen Carley on behalf of the respondent, Department of Massachusetts State Police, spelled STEPHENCARLEY. With me is my associate, Pamela Rautenberg.
Ma'am?
R-A-U-T-E-N-B-E-R-G.
Thank you very much, Mr. Carley and Ms. Rautenberg. This appeal was filed by the appellant pursuant to the provisions of Section 13 of Chapter 22C, which applies to state police disciplinary matters, and Sections 41 through 45 of Chapter 31, known as the Civil Service Law. The appellant is contesting the department's decision to terminate his employment as a state trooper. Under the applicable law, the burden is on the Department of State Police to show by a preponderance of the evidence that the appellant engaged in misconduct that warrants discipline. If the state police meets that burden, then the burden shifts to the appellant to show why termination, as opposed to a lesser penalty, was not the appropriate level of discipline. This hearing is conducted in accordance with the standard adjudicatory rules of practice and procedure, 801 CMR 1.01, formal rules, with provisions of Chapter 31 taking precedence over any conflicting rules. To ensure clarity, this is not a jury trial. This is an administrative hearing being conducted by a hearing officer. As such, it is my responsibility to make rulings on the admissibility of evidence and then determine what weight, if any, that evidence deserves, and to make credibility assessments as necessary regarding the witnesses that appear before me. Pursuant to Section 43 of Chapter 31, the Commission has deemed this a public hearing, while reserving the right to close portions of the hearing if warranted. Members of the public are present in the courtroom today, as well as an adjacent overflow room where the hearing can be viewed live. The media has been permitted to set up a pool camera for audio, video, broadcasting, and recording. Prior to the hearing, the media and public have been provided with a summary of hearing room protocols that must be adhered to at all times. This hearing is also being audio and video recorded by the Commission via the WebEx platform. A court reporter is also present to transcribe the hearings, and that transcription will be the official record of this hearing. At the conclusion of this proceeding later this year, the parties will be given the opportunity to submit post-hearing briefs, at which time the record will close. Any final decision issued by the Commission regarding this appeal will be sent to the parties via email only. The Commission's decision will also be published on the Commission's public website at mass.gov/CSC. All final adjudicatory decisions of the Commission are subject to judicial appeal under Chapter 30A of the General Laws. Before we begin, a few housekeeping matters. First, in a final ruling sent to the parties yesterday, and after considering the objections of both parties, I have entered into evidence 36 exhibits from the Department of State Police and 58 exhibits from the appellant. As those exhibits have already been entered into evidence, there is no need to request that they be entered prior to referencing them at today's hearing. Second, I accepted the department's participant list, indicating that the department at this time has only one witness, and we will hear from him shortly. The department has committed to completing direct examination of this witness today. It is the Commission's expectation that the appellant will complete cross-examination tomorrow, with the option of recalling this witness in October if necessary. I urge counsel for both parties to use your time wisely and make adjustments accordingly as the day goes on to ensure conformance with these time allocations. Third, I hereby order the sequestration of witnesses. Any individual who is a potential witness in this matter may not attend or view any part of this proceeding until the conclusion of their testimony. Fourth, counsel for both parties have been allotted 15 minutes for opening statements. Since the audio is being captured by the table microphones, I'm asking counsel as well as witnesses to please stay seated while speaking, to speak loudly and clearly, and avoid any crosstalk. Please allow questions to be completed before objecting. At this time, I ask that counsel for the Department of State Police proceed with an opening statement, to be followed by an opening statement by counsel for the appellant. I would ask Mr. Quinnen to please keep the time.
Commissioner McConaughey, may I just make a statement for the record regarding the procedure?
Is this something separate from the motions that I allowed yesterday?
No. Yes, it is. Yes.
Can this wait until after openings?
It can. It concerns the sequestration order.
If anyone is going to testify, or you think they will, they shouldn't be in this room.
No, the difficulty is the fact that we're here at the request of the Commission to start this process today, despite the fact that we're awaiting discovery from the department, as you know.
Sir.
And we don't know who all our witnesses.
One at a time, please.
Yes, if I'm speaking, don't speak.
Sorry.
That's quite simple. First of all, for decorum. If you have anyone who is a potential witness, they should not be in this room. That's all I can say.
And because we don't have our discovery, we don't know at this point who all of our witnesses are.
I can't advise you how to conduct your case.
I'm sorry?
I can't advise you how to